Hey guys, this is John Watts. I'm a consumer protection lawyer and I have a very interesting case. This involves Credit Associates, LLC. It's a huge debt settlement company and it's a lawsuit against them and against a credit bureau, Trans Union in this case, all related to some solicitation or junk mail that Credit Associates sent out. And we can see how just a letter being sent out can violate the Fair Credit Reporting Act, which might seem a little bit odd. But I'll tell you, at my firm, we always seem to have at least one case going where it is an unauthorized access or pulling of your credit report. In the Fair Credit Reporting Act, while we normally talk about it in terms of, it has to be accurate information, complete information on your credit report, the other side of that is they have to be very, very careful, the credit bureaus do, about who they let pull your credit reports. And if they do not follow the law, then the person pulling your report and the credit bureau can be liable. So let's take a look at this case. It just came out March the 10th. And I've tried to, hopefully I've kept the colors consistent, but light blue will be what Trans Union is doing, green will be the consumer, and yellow is really the court talking. So we have Trans Union is moving to dismiss the complaint or part of the complaint for what's called failure to state a claim. It just means take everything you say is true, you absolutely lose, consumer. That's what a motion to dismiss is. All right, so let's look at the facts here. And probably some of you watching have received a similar letter. So received a letter in the mail. It said you're pre-approved. Records indicate may have excessive credit card debt. And we have a debt relief program, no upfront costs. Typically this type of letter, and if you have some credit card debt, you're probably getting these like once a week, once a month. And it'll say, you may have $43,214 in credit card debt. You're like, how do they know that? Because they pulled your credit report without your permission. All right, so letter says pre-approval guarantees the extra deferral of fees that would otherwise be due after each account successfully resolved. Now let me say this. It's going to get a little detailed because we have a couple of concepts here. We have the FCRA, the Fair Credit Reporting Act, when they pull your credit report. And we have debt settlement companies that get to you through telemarketing. And these guys are forbidden to take a fee until after they settle the case. Now, there's a lot of these guys that try to work around that. They use sort of a bogus law firm model. Okay, so they'll say, oh, we're a law firm. They're not really a law firm. It's a scam, all right? And we sue these guys. But the ones that don't pretend to be a law firm, they cannot take any fees until after they settle your debt. So you're going to see it gets sort of down in the weeds between, well, can they charge you now? Do they have to charge you later? How does that interact with the Fair Credit Reporting Act? Pulling your report. I'll try to explain it as we go through, but just keep that in mind that that's coming. All right, then it says this pre-screened offer was based on information in your credit report. Now, they don't always say that, but they're supposed to say that. Okay. And a lot of times we can tell by looking at your real report, okay, yes, you did have your report pulled by this company or that company. So it's Credit Associates LLC, and the client or the consumer called and spoke with somebody, and there was no discussion of deferral of fees or extra deferral. And again, that becomes important on whether this is what's called a firm offer of credit. That's an allowable reason to pull your credit report without your permission, but it's very, very strictly interpreted. So then a second letter from this company, final notice, we may never contact you again, so contact us immediately. And it's basically the same thing. And it said, hey, probably $140 a month. And your pre-approval guarantees the extra deferral of fees that would otherwise be due after each account is successfully resolved. So consumer calls the number and they're told, hey, a law firm's going to handle your debt settlement. So even though this is Credit Associates, they're saying, but we have this law firm over here that will actually be working, and never offered any sort of fee deferral, there's no fee deferral and sales pitch, and they just don't do it because the fees are payable in full when earned. All right, so been targeted by direct mail marketing based on inclusion in pre-screened lists compiled and provided by Trans Union, never authorized credit associates to obtain her credit report. So what's the lawsuit? So sue credit associates and Trans Union alleging violations of the Fair Credit Reporting Act, and claims the FCRA was violated through willful noncompliance and negligent. So those are the two sections where you can sue under. If it's negligent, then you can get actual damages, so it could be economic and emotional distress, and attorney's fees. If it's willful, you can get statutory, which is up to $1,000, typically per violation, although some dispute about that. And you can get punitive damages. So they're saying not only did you negligently violate the law when you allowed my credit report to be accessed by somebody who had no right to it, but you did this willfully or recklessly or wantonly. In other words, you didn't have proper procedures in place, or you just sort of closed your eyes to the truth and allowed this to be happen. All right, so Trans Union moved to dismiss the claims, and so the consumer amended her complaint, then they moved to dismiss again, and then she amended her complaint again. So this is sort of the third version. You've got the complaint, first amended complaint, second amended complaint. Trans Union moves to dismiss those. So now the court will tell us what's the law on how are you supposed to plead a complaint, and then what's the standard when somebody tries to dismiss it. So short and plain statement of the claim, and you can't just sort of have formulaic recitations. You can't just sort of say the magic words and that opens the door to the court. This is something called Iqbal and Twombly. So for the lawyers watching, they'll be familiar with this if they practice in federal court. It's just sort of a heightened standard of pleading that we have to do basically in the last 10 or 15 years. And so you have to allege facts that state a claim to relief that is plausible on its face. And it gives you more than just speculation. So when is a claim plausible? When the plaintiff pleads factual content that allows the court to draw the reasonable inference defendant's liable. It's not saying the court has to be convinced, oh, you're definitely winning, or if I was the jury, you would win. It's just, is it plausible? I mean, is it, if I take your facts and I give you reasonable inferences, do I reach the result that, well, assuming all these are true, the defendant would be liable? If so, then it's plausible. Okay? And has to construe the complaint in light most favorable to the plaintiff and accept all factual allegations as true. So now we're going to switch to the Fair Credit Reporting Act. So what was that law passed for? There's a need to ensure consumer reporting agencies, that's places like Equifax, Experian, and Trans Union, exercise their grave responsibilities with fairness, impartiality, and respect for consumers' right to privacy. And so there have to be reasonable procedures to meet the needs of commerce while giving due regard to the interest and confidentiality. So a consumer reporting agency like Trans Union may furnish credit reports for these identified or enumerated purposes only. So the FCRA spells out, here are the reasons that you, the credit bureau, can allow somebody to pull a report. So it must be reasonable procedures to limit the furnishing of consumer reports to the purposes listed in Section 1681B. So here's what Trans Union has to do. And the focus of this order is not on credit associates. I mean, they got their own liability for violating the Fair Credit Reporting Act if they pulled a report illegally. But we're just focusing now on Trans Union. So recipients of consumer reports, here, credit associates, identify themselves, certify their intended use, and they're only going to use it for that purpose. So you can't say to a credit bureau, I want to get a report for this reason, which is legitimate, but then I'm going to use it for an illegitimate. No, they have to promise I'm only going to use it for the reason I pulled the report. Then Trans Union has to make reasonable effort to verify this information, and they can't furnish the information if there are reasonable grounds for believing they will not be used for a certified purpose. So Trans Union can't just close its eyes. It's like, hey, this company's coming to us, but we're getting the sense they're not doing what they're saying they're doing. Well, you got to cut them off. So many of the permissible purposes do not raise privacy concerns. Why is that? Because they're initiated by the consumer. So I go to a mortgage broker and say, will you please pull my credit report, tell me if I'm eligible for a loan? Well, I can't say that. Oh, I'm outraged that you invaded my privacy by pulling my credit report, because that's what I went to you for. But there are some circumstances that the Consumer Reporting Agency may furnish a report to a third party without the authorization. That's where we start going, wait a minute, there's a lot of privacy concerns here. So here's an example, and this is what the case is about. You can give a report without authorization if it's a firm offer of credit or insurance. And so Congress is balancing the privacy concerns created by pre-screening with the benefit of a firm offer. So the idea is, yeah, you're giving up some privacy because somebody's pulling your credit report without your permission. But on the other hand, you get a firm offer of credit. It's not like, hey, call us and then we'll see if you qualify. It's, hey, we pulled your report and you are absolutely qualified. And so kind of a give and take there. You lose a little privacy, but you get a firm offer of credit. Now, this case is about, was there really a firm offer of credit? So the consumer, she alleges they negligently, willfully violated the FCRA by giving her report without a proper purpose. Trans Union says, hey, the deferral of fees and the mailers, in other words, the letters, constitute a firm offer of credit, and you did not try to accept that, so you lose. Now, the second argument is just ridiculous by Trans Union. Never be surprised at how ridiculous the credit bureaus will be in making arguments to try to get out of liability. So the consumer disagrees and says, hey, the mailers do not constitute a firm offer of credit. And here's 3 reasons. Number 1, it's just not a firm offer of credit. Number 2, even if they were firm offers of credit on their face, in other words, they appeared to be, when you look deeply, it's really a sham offer. And then number 3, credit associates never intended to honor the offer. So even if it appears to be an offer, firm offer, and it doesn't appear to be a sham, they never intended to honor it, so it doesn't qualify. And so let's see, firm offer of credit or insurance, but we're really just focusing on credit here, is defined as an offer of credit to a consumer that will be honored if the consumer is determined, based on the information in the consumer report, that's where they pull your report, to meet the specific criteria used to select the consumer, except the offer may be further conditioned on 3 specific conditions. So, what's number 1? May apply additional pre-selected criteria bearing on the consumer's credit worthiness. So that might be like, well, your credit score looks good, but we have to make sure that you make enough income. Okay. Second, condition on verification that the consumer continues to meet the specific criteria used to select. In other words, I might meet it today when they pull my report, but 2, 3, 4 weeks later when I'm talking to them, my credit report is just tanked. Well, they're not obligated to make it. But here's the third thing. Finally, the offer may be conditioned on consumers furnishing any collateral that was established before the selection and disclosed. So if they say, hey, we want to make you a loan on your house, maybe refinance your house, and here's a firm credit, but obviously you have to put your house up for collateral. Well, they have to tell you that in the letter. They can't just say, hey, we'll give you a $200,000 credit, you're approved, and then you call and they're like, but you have to mortgage your house. Well, you have to tell me that in the letter. So a consumer says, well, these do not include a firm offer of credit because there's a condition precedent. That means something has to happen first that does not fit into those 3 categories. So this is where we get back into the rules on debt settlement. Federal regulations already required the deferral of fees until the achievement of a successful resolution. That's just the law, okay? So judge says, yeah, that appears to be so. And so the required deferral comes into play immediately. The extra deferral that constitutes the proffered credit, because remember, that's what the letter said, hey, we'll defer these fees, only comes into play after the account's been successfully resolved, and only if it's successfully resolved. This creates a condition precedent. So the consumer would have to enroll in the program first, stay in the program until a successful debt renegotiation was achieved, if ever, and only if all that occurred would Credit Associates be obliged to honor its offer of an extra deferral of fees. So again, we're getting kind of complicated into this, but just understand the court is really looking at this letter saying, hey, are you really offering something of benefit here? And the condition precedent is not one of the conditions that the statute permits the firm offer to include. So it's not a firm offer of credit. And then the judge is going to say, well, let's just assume, for sake of argument, it was a firm offer of credit, even though it's not. You still lose, okay? So Hopper's pled sufficient facts, accepted as true, that the offer was a sham, okay? So when's it a sham? When the offer is merely a guise for solicitation, not a legitimate credit product. So in this case called Cole, the mailer guaranteed a line of credit of at least $300 toward the purchase of a vehicle. And they say definition of firm offer of credit does not incorporate the concept of value to the consumer. That does not incorporate the concept of value to the consumer. Upsets the balance Congress carefully struck between the interest in privacy and the benefit of a firm offer. And so they said, hey, that was just a sham, what you were doing. Now, there was a subsequent case called Murray that says the Cole case, the one we just looked at, is beside the point for pure offers of credit. So when credit reports are used to make offers of credit and nothing but, the question is simply whether the offer was firm without regard to value. So if it's something besides just credit, then we have to look at it and say, well, is there true value here? But if it's pure credit, then it's just a matter of, did they offer you an actual firm credit? So the question is, does this case fall under Murray as an offer of credit and nothing but an offer of credit, or does it fall under the Cole case as an offer of credit wrapped within an advertisement for products or services? TransUnion says, hey guys, it's pure offer of credit. The consumer says it's solicitation. And the court says, well, Credit Associates offered participation in debt relief program. That's a service, okay? As well as an extra deferral of fees. That's the credit. It is therefore not a pure offer of credit, but an offer of credit wrapped in an advertisement. So it's plausible that the offer of credit was for a guise for solicitation, and the consumer says those fees were only deferred until the account is resolved, which is already required under the rules. So you're kind of offering me nothing, okay? Credit Associates was thus offering nothing more than that which it was already required to offer. You know, it's kind of like saying, you know, your boss saying to you, well, if you do, you know, you worked 80 hours the last 2 weeks, so I'm going to give you a gift of your paycheck. You're like, no, I earned that paycheck. That's not a gift, okay? You're not giving me anything extra. That's already mine. Well, when you sign up with these debt settlement companies, they're not supposed to. They break the law all the time. They need to be sued. But they're not supposed to take your fees until after they resolved your case. Well, the promise in the letter was, you know, we won't take your fees until later. Well, you have to wait till later anyway. So it's kind of meaningless. And so that's what the court says. That's the case, and this offer was an illusion, was offered no credit, and this was not a firm offer of credit. And then there's the third argument that the consumer made, and that is Credit Associates never intended to honor it. So even if it was a firm offer of credit, even if it wasn't a sham, they never intended to honor it. So the statutory definition of firm credit offer is an offer that will be honored, not likely or maybe or possibly, but it will be honored. So the consumer alleges Credit Associates never does and never intended to honor the offer, and it knows that the third party for which it markets, that was the law firm, requires payment in full when earned without granting any extra deferral. So now we come back to TransUnion. Here's a really silly argument. I mean, TransUnion's lost, okay, this motion to dismiss. Not saying they lost the case because the consumer has to prove all this, but here's their second argument. Must allege that the consumer attempted to accept the offer or else the theory fails. And the court says, This is an unsupported premise that the consumer must first attempt to accept the offer before it can be established that the offer never intended to honor it. Such a presumption would require the consumer to attempt to accept even the most blatantly false offer simply to get past starting line. So, this is TransUnion sort of thinking this up, and the judge say, what, are you crazy? That would be ridiculous. If it's obviously a false offer, you don't have to definitely accept it or even attempt to accept it. You can just point out it's a false offer. And here the alleged injury is the invasion of privacy. So this is not a breach of contract. It's invasion of privacy. Well, when did that happen? When TransUnion furnished credit associates with the consumer's credit report without her consent and without a proper purpose. Only needs to plead that credit associates never intended to honor the offer. Does not need to plead she attempted to accept it. And then this judge is doing this in a very good way, saying, you lose, but even if you don't on that, let's go to the next point. You lose there, but even if you didn't lose that, you lose the next one. So even assuming an attempt to accept is prerequisite, such an attempt is readily inferable. Remember, that's the idea of motion dismiss. We look at what's pled and then the reasonable inferences that flow from that. So the consumer alleged she called credit associates twice. And the court says we can reasonably infer when she called, she was attempting to accept the offer, because you don't typically call the number to reject the offer. If you intend to reject it, you just throw it away. And so the motion to dismiss is denied. Here's a couple of footnotes. There's a thing called the TSR, telemarketing sales rule, and that's really where we get into that idea of a debt settlement company that's doing stuff by telemarketing, that they have to, there's a bunch of requirements, but one is they don't get paid till after they actually do the work and accomplish the goal. And TransUnion says, oh, well, you're now making a claim under this. And the court's like, no. Just observing the deferral of fees until successful resolution is required. So it's meant to illuminate the distinction between the required deferral and the extra deferral being offered as credit, which was really just a sham. And then the TransUnion was arguing this regulation doesn't matter. And the court says, well, it prohibits sellers and telemarketers from requesting or receiving fees until the seller or telemarketer has renegotiated, settled, reduced, or otherwise altered the debt. In other words, you have to accomplish the goal before you can take the money. And so what's telemarketer? What does that mean? Well, one who in connection with telemarketing receives telephone calls from the customer. So it's not just they're making telemarketing calls, but they're sending something out that is then prompting a call back. Okay. In turn, telemarketing is defined as pertinent part of a campaign to induce the purchase of services. The mailer instructed the consumer to call. Pretty good argument. And the definition of telemarketing excludes solicitation of sales through mailing of a catalog. So TransUnion goes, hey, this was a catalog. But only where the catalog includes multiple pages of written material or illustrations to meet other requirement. This was only one page. And so it looks like it's meant to include telemarketing used as a one-page mailer as a lure. So here's a bottom line message to this. If you are dealing with this company of credit associates and they sent you a letter, or you're dealing with any other debt settlement company, they sent you a letter, even if you didn't respond to it, if you have these letters laying around on your kitchen table or in your office, your desk, wherever, it's worth looking at and seeing, does it say on there that they pulled your credit report? If it doesn't, they still may have, and that's really a violation to not notify you of that. But I would take a look at those, and if you want us to take a look at them also, just reach out to us at alabamaconsumer.com. You'll see a contact us on there. You fill out that form, and they'll send a message to us. You'll get an automated email, and you can reply to that, and then I'll personally respond to you, either calling you, emailing you, sending you a video, whatever's appropriate. And be glad to look at these, because this is a huge problem where all these companies are sending out these letters, but it's based on pulling your credit report without permission. So the credit bureaus are at fault and the company pulling is at fault. So if we can help you in any way, just let us know. But even if you don't do that, I want you to see this case because it's a really fascinating case. And I think that the judge does a great job of sort of getting rid of all these arguments by TransUnion. And some are legitimate arguments that are just wrong. But then, that second argument about, well, you have to, accept it to show it's false. That's just, typical of the credit bureaus. Very typical. So hope you enjoyed this, and I appreciate you watching it, and I'll catch you guys tomorrow. Have a good one. Bye-bye.